E-Discovery in Today's World by Tracy Bocchi. What is e-discovery? E-discovery is the electronic version of trial discovery. It occurs at the beginning of litigation and requires each party to adhere to the other's request for information relating to the particular case. E-discovery can include such things as word processing documents, spreadsheets, databases, emails, websites, and social media. Audio and video can be included in this as well. The roots of e-discovery. Federal Rules of Civil Procedure. The Federal Rules of Civil Procedure, FRCP, were adopted in 1938 and were then amended in 1980, 1983, 1993, 2000, and 2006. FRCP created an equal playing field for everyone, regardless of status, at trial, and it prevented trials by ambush. E-discovery in today's world, negative impact on organizations. 99% of the world's documents are now stored electronically, which can lead to thousands of documents in any given case. E-discovery has placed a huge financial burden on parties involved in lawsuits. Abuses in e-discovery are common, causing lawsuits that are frivolous to settle out of court due to the unfair burden that e-discovery may place on a defendant. E-discovery can be impossible to manage without the appropriate IT staffing, equipment, and software. E-discovery in today's world, positive impact on organizations. Direct cost savings accrue year by year. Rigorous policy implementation and directed technology investments diminish business disruptions and reduce legal risk in future years. As litigation exposure increases, costs are now far better contained. E-discovery can eliminate the need for paper, hard copy documents during discovery so organizations can incur some cost savings. Physical storage, such as filing cabinets, is replaced by virtual space. Addressing e-discovery before a lawsuit occurs. An organization must be proactive in today's litigious environment. Staffing. Hire staff that are knowledgeable in this area. Designate a manager of information systems to oversee electronic records management. Policies and procedures. Organizations should implement clear policies with regard to electronic information. They should ensure that policies and procedures for electronic information management are kept updated according to changing technology and organizational growth. Invest in the appropriate tools to manage the process. Organizations should conduct thorough research when investing in software and always make sure that it can grow and change with the times. They should also ensure that they have sufficient equipment for record retention. They should ensure that naming conventions are consistent and that staff is educated. Organizations should always safeguard information systems through use of backup by tapes or off-site storage. Organizations should safeguard investments. Training staff is crucial to ensure both software and equipment is used properly. Again, backup of information systems through use of tapes or other forms of media should always be in place. Virus and malware software should be installed to prevent systems from being compromised. Skyrocketing costs of e-discovery caused by technology. Mid-sized case now involves at least 500 gigabytes of data, resulting in costs of $2.5 to $3.5 million for electronic discovery alone. Advancement of the American legal system confirms that efforts to rein in discovery costs and end discovery abuse have generally failed. The volume and cost of discovery in the electronic age amount in some cases to billions of pages and millions of dollars. Finding software to meet the needs of your organization. There are hundreds of different softwares available. Information managers must do their homework as technology is ever-changing. Find a document manager that meets both the budget and the needs of the organization. Custom programs versus package programs. Custom programs will generally be more costly, but will be designed to meet your specific needs. Package programs, on the other hand, are a one-size-fits-all, but the size may be just right for your organization. Outsourcing e-discovery. An organization's size and software cost can be a huge part of the decision as to whether or not this function will be outsourced. Many companies who are versed in this area are available to assist both small and large organizations with e-discovery. A careful assessment of organizational needs must be completed. Organizations that are not prepared for litigation may go this route due to lack of experience in this area. Outside counsel or even in-house counsel may prefer the expertise of such a firm. The legal system has changed rapidly with technological advances. As legal professionals, it is our obligation to be well-versed in the area of e-discovery so that we can present the best options to clients. The World Wide Web offers hundreds of resources for legal professionals to become educated in the area of e-discovery. The American Bar Association, as well as local bar associations, offer great resources for those legal professionals who have not yet ventured into this area.